Good morning, Miss. My name is Chua Dongwei, and today I'm going to present my video assignment for IP law. And this is the question. Patents, trademarks, copyrights, and industrial designs are valuable assets of the company, and understanding how they work and how they are created is critical to knowing how to protect them. Intellectual property law is a form of legal protection which prevents others from copying or imitating the work of the original creator. Most intellectual property rights in Malaysia are protected by way of statutes. The intellectual property in Malaysia are mainly protected by several statutes as introduced in the following slide. They are Copyright Act 1987, Patents Act 1983, Industrial Designs Act 1996, Trademarks Act 2019, Geographical Indications Act 2000. First, with regard to the Copyright Act 1987, this act provides for the categories of works eligible for copyright, the nature and duration of copyright, performance right, moral rights, the infringement of copyright, the offences related to copyright, the commercial exploitation of copyright, the copyright tribunal, and the enforcement of copyright. Copyright comes into existence automatically. Protection under the law of copyright is not conditional upon registration. Before any works may be protected, it must fall within one of the categories of protected works. It must be original in the sense that it was the result of the skill and effort of the author or creator, and it must be in some material form. Regarding the issue of originality, such works are works by authors and sufficient effort are required to be done to the work. As stated in Section 7(3)(a) of the Copyright Act 1987, a literary, musical, or artistic work shall not be eligible for copyright unless sufficient effort has been expended to make the work original in character. It should also be noted that this requirement in copyright law does not require the work to be unique or to achieve any meritorious or artistic level. As provided in Section 7, Subsection 2 of the Copyright Act 1987, the works shall be protected irrespective of their quality and the purpose for which they are created. In addition, the originality requires work to originate from author, and this concept is illustrated in the case of Goodyear Tire and Rubber Company and Silverstone Tire and Rubber Company Senamba. Secondly, the works need to be reduced to a material form. Section 7(3)(b) of the Copyright Act states that a literary, musical, or artistic work is required to be written down, recorded, or otherwise reduced to a material form in order to be eligible for copyright. It is a fundamental principle of copyright law that copyright does not protect the underlying of work but protects the expression of the idea. According to Section 10, Subsection 1 of the Copyright Act, it is shown that copyright shall subsist in every work eligible for the copyright of which the author, or in the case of a work of joint authorship, any of the authors is, at the time when the work is made, a qualified person. Section 10, Subsection 2 shows that copyright shall also subsist in every work which is eligible for copyright and which, being a literary, musical, or artistic work of film or sound recording, is first published in Malaysia. In addition, Section 10, Subsection 3 illustrates that copyright shall subsist in every work eligible for copyright if the work is made in Malaysia. In Malaysia, it is codified in Section 26(1) of the Copyright Act, which provides that copyright shall vest initially in the author, who can, by way of a written instrument, transfer his or her copyright to a third party in exchange for a monetary sum. Often, the author of a work is also the copyright owner of the work, although it is common for a work to have a separate author and copyright owner. The author, as owner for the copyright, may assign, transfer, transmit, or grant license in respect of all of some of its rights under copyright. Hence, the author of a work may not necessarily be the owner of a copyright, and vice versa. However, there are exceptions to this rule which can be found under Sections 26(2) and 3 of the Copyright Act, which encompass a work made under an employment contract, a commissioned work, and work carried out under the direction of control of the government. Pursuant to Section 26, Subsection 2(a) of the Copyright Act, an employee whose work is created in the course of his or her employment is not entitled to be the initial owner. Instead, ownership of the created work lies with the employer unless otherwise agreed between both parties. In Syarikat Faizal Senam Berhad in another, and Fayez Rice Senam Berhad in another. The court held that since the first plaintiff's business was indeed trading in rice products, there was no reason that the second defendant, who was one of the four co-authors of the original works, would create the works other than for use by the first plaintiff's business. Therefore, the works were likely to have been made in the course of a second defendant's employment with the first plaintiff, with him being their general manager. In Active Bonding Senam Berhad and Zenaf and Associates Senam Berhad, it was held that by the court that the signing of the letter of intent constitutes a commission under Section 26(2)(b) of the Copyright Act, and therefore, while the plaintiff is the author of the drawings, the ownership of the copyright subsisting in the drawings was transferred to the main contractor, who commissioned the said drawings by virtue of Section 26(2)(b) of the Copyright Act. In summary, the copyright owner is only entitled to control the first distribution in Malaysia, but there is an exception. The copyright owner continues to control the commercial rental of copyright works, a right that is not extorted by the act of the first distribution. Where copyright work is created in the course of one's employment or as a result of a commission, the ownership of the work is transferred automatically to the employer or the person who commissioned the work, save where the parties have signed an agreement to the contrary. Notwithstanding the fact that the ownership of the copyright in the work may be vested in a person other than the author, the latter is still the only person who is entitled to exercise the moral rights granted under Section 25 of the Copyright Act. Now we move into Patents Act. This act deals with the protection of inventions that are new, involve an inventive state, and are industrially applicable. Patents rights are acquired by way of registration under the Act. The Patents Act 1983 has set a general principle in favor of patentability for inventions which meet the following criteria laid down in Section 11, which are the invention is new, it involves an inventive state, and it is industrially applicable. Regarding the first requirement, which is the novelty, pursuant to Section 14 of the Patents Act, an invention is new if it is not anticipated by the prior art. The second requirement for a patentable invention is that it must involve an inventive state. The inventive concept of a claimed invention is discerned from the claims of the patent. Even though an invention is novel, it is not patentable if it fails to meet the inventive state requirement. Pursuant to Section 15 of the Act, an invention shall be considered as involving an inventive state if, having regard to any matter which forms part of the prior art under paragraph 14(2)(a), such inventive state would not have been obvious to a person having ordinary skill in the art. The third requirement for a patentable invention is that it must be industrially applicable. Section 16 of the Act provides that an invention is industrially applicable if it can be made or used in any kind of industry. The owner of a patent can exercise the right to control the use of the patent, to work the patent, to deal with the patent, and to sue for infringement. Pursuant to Section 18(1) of Patents Act, it provides that any person may make an application for a patent either alone or jointly with another. In addition, pursuant to Section 18(2) of the Act, general rule says that the right to a patent belongs to the inventor. Inventor is a person who produced the invention, while the patent owner is the person whose name is recorded in the register of patents as the grantee of the patent. According to the Regulation 6 and Regulation 10 of the Patents Regulation 1986, the applicant needs to state the identity of the inventor and provide a statement justifying his right to the patent where the inventor does not make the application for a patent. The owner of a patent who is registered as the grantee of a patent has the exclusive right to control the use of the patent and may sue for patent infringement according to Section 36(1) of the Patents Act. In some circumstances, the third party has a better entitlement to the patent. Thus, he is entitled to apply for the patent. First exceptions, Section 19 of the Patents Act 1983 provides that the essential elements of the invention claimed in the patent application or patent has been unlawfully deprived from an invention for which the right to the patent belongs to another person. Such other person may apply to the court for an order that the said patent application or patent be assigned to him with a period of 5 years. Second exception is regard to Section 21. It illustrates that the right to a patent for an invention made in the performance of a contract of employment or in the execution of a commissioned work is deemed to accrue to the employer or the person who commissioned the work. Section 22 aims to protect the employee who has successfully made an invention which is within the field of activities of his employer by using the data or means placed at his disposal by his employer when the contract of employment does not require him to engage in any inventive activity. The third exception is regard to Section 23. It provides that the inventor's rights shall not be restricted by contract and should apply equally to a government employee. In a nutshell, it is above mentioned that the owner of a patent is not necessarily be the inventor of the patent. There are some exceptions that the third party or the other person can claim for the said patent with the better method than the inventor himself. Regarding the fairness of this principle, it can be said that it's quite fair in this matter of patent, as some inventors may not like to expose himself and his product due to some reason. So he will pass his invention to somebody else in order to benefit the public. Now we come to Industrial Designs Act 1996. This act provides for a system for the registration of industrial designs, and industrial design comprises features of shapes, configuration, pattern, or ornament that are applied to an article by an industrial process. According to Section 3 of IDN 1996, industrial design means feature of shapes, configuration, pattern, or ornament applied to an article by an industrial process or means being features which in the finished article appear to and are judged by the end. To be capable of registration under the Industrial Designs Act, firstly, it should be a registrable design. Regarding the features of the design, anything which is in substance a mere mechanical device cannot be registered as a design. To be registrable as design, the features of shape or configuration must be features beyond those necessary to enable the article serve its function. The shape, configuration, pattern, or ornament must be applied to an article by an industrial process or means. In Siti Khadijah Apparel Sdn Bhd and Aryani Textiles and Manufacturing Sdn Bhd, it was held that a telekung, which is a Muslim prayer outfit, was not an industrial design because it was not applied by an industrial process. Besides that, the designs must be appeared to and be judged by the eye. Last but not least, regarding to the industrial design which is contrary to public order or morality, it shall not be registrable under Section 13 of Industrial Designs Act, although it fulfills the definition of an industrial design and is new. The author of an industrial design is the person who creates the design, but the owner is the person who is registered in the Register of Industrial Designs as the owner of the registered industrial design. Section 32(1) provides that the owner has the right to enjoy the exclusive right conferred upon him, and he also has the right to bring infringement actions to protect his exclusive rights. The ownership of an industrial design is secured by way of registration in accordance with the requirements of the Industrial Designs Act 1996. Section 11(1) of IDA states that the original owner of an industrial design is entitled to make an application for the registration of the industrial design. Thus, original owner is defined as the author of an industrial design in Section 10, Subsection 1 of the Act. Section 10, Subsection 5 of the Act provides that the other person shall be treated as the original owner of the industrial design and accordingly is entitled to make an application for the registration of the industrial design where an industrial design is assigned or transmitted to another person by the original owner. There are few exceptions to the general rule. The first exception, according to Section 10, Subsection 2 of Industrial Designs Act, When industrial design is created in pursuance of a commission for money of money worth, the person commissioning the industrial design is the original owner of the industrial design. The second exception, pursuant to Section 10, Subsection 3 of ITA, the exception applies when industrial design is created by an employee in the course of his employment. In such a case, his employer is the original owner of the industrial design, and this can be seen in the case of F&N Dairies, Malaysia Sdn Bhd, and Tropicana Products, INC, and other appeals. Now we move on to Trademarks Act 2019. This act provides for the registration of trademarks, the criteria for registration, prohibition on registration, trademark renewal, the nature of the exclusive rights of the trademark owner, the circumstances under which a trademark is infringed, the situations when the continued registration of a trademark may be challenged, the commercial exploitation of the registered trademark, including its use as a collateral for raising funds and the enforcement of trademarks. Trademarks are names and/or symbols that a company uses to identify goods or services in the marketplace to indicate a connection in the course of trade between the goods and services and the trademark owner. Trademarks can consist of a logo or company name, a unique packaging style, or a combination thereof. It can be said that the primary purpose of trademark is to prevent consumer confusion as to the origin of a particular good or service by prohibiting a subsequent competing business from using an identical or similar name or symbol. Trademarks are registered in the country in which protection is sought with the country's register of trademarks and are generally issued for one or more categories of goods or service at a time. The registrability of trademarks would depend on the distinctiveness and the non-confusing character of a proposed mark. Last but not least, move on to Geographical Indications Act 2000. This act provides for the registration of geographical indications and defines the protection that is granted to geographical indication owner, whether the geographical indications are registered or otherwise. The availability of the law of passing off in accommodating the protection of geographical indications was affirmed by the High Court in the recent decision of the Scotch Whisky Association and another, and when Winery Sdn Bhd. In that case, the plaintiffs, which had the proprietary rights over the goodwill and reputation of the Scotch whisky trade, claimed that the defendants has passed off the defendant's spirit, which were not distilled in Scotland, and F and for Scotch whisky. There are 5 elements to be established in order to succeed in the action of passing off. These elements are: first, a misrepresentation; secondly, made by a trader during his trade; thirdly, to a prospective customer of his; fourthly, which is calculated to injure the business or goodwill of another trader; and fifthly, which causes actual damages to the business or goodwill of the trader by whom the action is brought or would probably do so. As a result, all these elements were satisfied, and the court had issued an injunction against the defendants to prevent them from continuing with their acts of passing off. How to protect the intellectual property? Intellectual property infringement can create negative impact to inventor or author, consumers, industry, and also to the country. It is because intellectual property infringement harm both inventor or authors and companies through loss R&D revenue, the cost of intellectual property protection, damage to brand, and decreased incentives to innovate. In order to raise awareness of public regarding the intellectual property, there are various ways of cultivating an awareness of intellectual property protection. This includes organizing seminars and workshops, setting up an intellectual property office, formulating policies, participating in international treaties on intellectual property, organizing promotional activities and rewards, and through enforcement or inculcating the right attitude. In conclusion, intellectual property rights are very much essential for progressive societal development. The IPR is a basic necessity to a part of local as well as global competitive trade, as without dissemination of IPR knowledge and implementation, creating the innovative environment is really impossible. It is essential for policymakers to include IPR in basic educational system and promote IPR legislation by encouraging the innovators and creators. However, sometimes the creator or the author of intellectual property is not necessarily the owner of the said intellectual property. It can be seen in the situations above mentioned. Although it looks like quite unfair to most of the inventors or the creators, as the public will not have the chance to know their names of their invention, but due to some reasons such as financial issue, the inventor will choose to passing off or sell his invention to others to earn income. As a result, the fairness of the mentioned principle depends on how the feeling of the creator and the owner. Likewise, the owner can still introduce the inventor while his invention is being sold or promoted in the market. So that's all for my presentation. Thank you, Miss. And this is the journal articles and book statutes as well as cases that I used for this presentation. Thank you.